Good morning, everybody, and welcome to this Harrison Clark Rickaby's Covid-19 webinar. It's our first Covid-19 webinar that we're offering, and this morning we have speakers from a range of our business services teams. We're going to start with a presentation from Harry Ben-Goff on business interruption loans, followed by a presentation from Rachel Roberts on coronavirus job retention and furloughing. And then we're going to move on to a presentation on commercial contracts from Dan de Saules, followed then lastly by Richard Morgan talking about business interruption insurance. For those of you that have joined us before for seminars that I've chaired, you'll know that previously we've always offered a very interactive event and taken questions as we've gone along. But today, unfortunately, as it's a webinar, we're not going to be able to do that. Instead, we're going to have time for an extended Q&A at the end of the webinar. Thank you to those of you who submitted questions when you booked in for the event today. And we'll pick up on a few of those in the Q&A. And also, we'll take questions live from attendees using the Zoom chat facility. So keep those questions coming in as the event runs, and we'll keep an eye on those questions and we will pick on some of those. Any questions that have been submitted either before the event or during the event, if we don't answer them in the Q&A, we will pick up on them later, because we're going to circulate after the event a copy of this webinar and also a brief Q&A dealing with all the questions and issues that have been covered. So hopefully that explains the format this morning, gives you everything you need. So let's start off with a presentation from Harry Ben-Goff. Harry leads our banking team across the firm, and he's going to speak to you this morning about business interruption loans and what he's currently seeing. So Harry, over to you.
Thanks, Robert. Morning, everyone. As Robert mentioned, I'm going to be speaking about the main government loan schemes that have been introduced since the COVID-19 outbreak. Before I get into some of the detail, I just want to spend the first few minutes outlining the genesis of these schemes so you can see how we got to where we are today. At the core of the funding schemes is the Coronavirus Business Interruption Loan Scheme, known as CBILS. This was originally a rehash of the Enterprise Finance Guarantee Scheme that was put into existence after the 2008 financial crisis as a way of improving liquidity in the debt market. That scheme has since been shown to be largely ineffective due to a number of reasons, principally due to the restrictive qualification criteria and the fact there are only a limited number of lenders that could provide the loans. Understandably, therefore, there was somewhat of a collective groan when it was announced that CBILS would mirror that scheme. There's no doubt that the CBILS scheme was launched in a hurry, and it was well acknowledged that it would need refinement as we went along. And we've certainly watched the scheme change a fair amount since its inception, predominantly as a result of growing pressure from the business community. Turning to each of the schemes in a bit more detail. As mentioned, the core scheme, CBILS, is aimed at UK businesses that were viable pre-COVID, but have lost revenues or have had disruptions to their cash flow as a result of the pandemic. Any businesses applying must have a turnover of no more than £45 million and must generate 50% or more of its turnover from trading activity. Loans can be for up to £5 million, with a number of banks limiting this to 2 times 2019 annual wage bill, or 25% of your turnover. And the government will kind of pick up the tab for the first 12 months' interest. In terms of security and guarantees, banks can look at usual options available to it. However, they can't take any personal guarantees on loans below £250,000. And security can be taken over principal residences. Personal guarantees are taken for larger loans. one key phrase just mentioned above, which I'm going to pick out, is that he proved that it was a viable business prior to the COVID-19 pandemic. Viability is one that a bank's credit team will assess. There's also an underlying test within this broad statement, which is derived from EU law on state aid. That businesses must not be an undertaking in difficulty. What this means is that if the business has accumulated losses greater than half of its subscribed share capital, not be eligible for the scheme. In practice, this means that certain fast growth businesses may not be eligible, and in particular sponsor-backed businesses that use a lot of debt already. As you can imagine, PE are lobbying on this point quite hard. Crucially, you should know that while the government is guaranteeing 80% of all losses, the borrower remains 100% liable to pay the debt. The lender explore all usual recovery angles before seeking recourse from the guarantee. So at the same time as Sybil's was launched, the Bank of England introduced the COVID Corporate Finance Facility, which was commercial paper rated businesses. These are effectively very large businesses that can access short-term debt in the money market. I propose to dwell on this facility, as I suspect it's outside of the remit of those on this webinar, but to say between Sybil's and CCFF, it left a huge funding gap known as the squeezed middle. It took a while, but the government then launched CLIBLs or CL bills, which is the large version of the Sybil scheme, and businesses with a turnover of 45 million and above. It has very similar features to Sybil's, but with key differences that loans are available up to £50 million, and the government will not cover the first 12 months of interest or fees. Since Sybil's, CLIBLs and CCFF, the Chancellor announced on the 20th of April that he's established a new future fund to support UK's innovative businesses currently affected by COVID-19. These are businesses that have been unable to access other government schemes because they're either pre-revenue or pre-profit and typically rely on equity investment. The scheme will deliver an initial commitment of 250 million of new government funding, which will be unlocked by private investment on a match-funded basis. The scheme is being developed in partnership with the British Business Bank with intention of launching for applications this month, and will issue convertible loans between £125,000 to £5 million, subject to at least equal match funding from private investors. And then finally, we've got the Bounce Back loan scheme, which was only available from yesterday. And this will help small and medium-sized businesses to borrow between £2,000 and £50,000. The government will guarantee 100% of the loan this time, with no fees or interest to pay for the first 12 months. Loan terms will be up to 6 years, and no repayments will be due during the first 12 months. Now, I'm really conscious that the above, what I've just said, is a lot of information to take in. And we've developed a table detailing each of these schemes and their key terms, which we can send to you after this webinar if you get in touch, or indeed it's available on our website. Next slide, please. So once you establish which scheme you want to apply for, you'll then need to make the application itself, which will, in the majority of cases, be with your existing bank. I've listed a few points you need to consider when doing so. Information requirements will be substantially the same with a well-structured funding request and will be central to the success and speed of the outcome. Acting fast remains paramount to meet required funding timescales, given the volume of requests that are being managed by lenders currently. Make sure you consider all other government support available, some of which will be touched upon later in this webinar. Banks will want to see that you've considered these options when looking at your application. In terms of the amount you're applying for, ensure you're not asking for more than is necessary. If you ask for too much, you may get turned down, and reapplying may be extremely difficult or even too late for some businesses. You should also consider what security is available for the business and keep up to date with the criteria as it does move. And then finally, I've just mentioned there, you should consider advisory services. At a time where management will want to concentrate on running businesses, you should question whether it makes sense to actually outsource this work. Next slide, please. So finally, I just want to mention what you should do if you get turned down from one of these schemes. Well, first off, not all is lost. There are a number of lenders out there who can deliver each of the schemes, so you can approach any of them. Just a word of warning on this, however, these lenders are inundated with requests at the moment and therefore are predominantly servicing existing customer requirements. You could, of course, consider other capital raising options, such as an equity raise. And I have again just mentioned advisory support. And just to mention, we've teamed up with a few debt advisory specialists to help support clients through this process, including collating information and producing reports in support of loan applications. So please do get in touch with me after this webinar if you want to hear any more on that. So with that, Robert, I'm going to hand back to you. Robert, you're still on mute, just so you know.
Thanks, Harry, for that really useful update from you there on the latest facilities available from the government. We've already had some questions come in. I can see the questions coming in thick and fast. So thank you to everybody for those that are coming in already. The temptation for me as chair is to want to jump in and start answering those questions, but that's not the format today. So please bear with us while we wait to get to the end. So thank you, Harry. We're now going to pass it over to Rachel Roberts, who's a partner in our employment team. And Rachel's going to talk to you about the job retention scheme and furloughing. So Rachel, over to you.
Good morning, everyone. Thanks, Robert. Yes, the F word. I know you've all been thinking about it, and yes, I'm going to talk about it. Furlough is everywhere at the moment. The good news, though, is I'm not going to make your brain hurt because there is no law to do that with. The government haven't given us any. But I am going to give you a few ideas, roadmaps, and some ideas of how we can help. So firstly, just looking at furlough, it's a new word. We hadn't heard of it 2 months ago. Has no legal definition. And all we are going on as employment lawyers at the moment is the government guidance. Well, 9, 10 reiterations of it so far, I think, and the Treasury directive. Yet we find ourselves in a situation where over 4 million workers have now been furloughed. It's anticipated that about 9 million will use the scheme overall, and 2/3 of UK businesses are actually using the scheme. So huge. If you haven't considered it, I'd be surprised, but I would strongly urge you to do so if you haven't. But on the basis of the statistics I just said, I'm guessing that most of you are already probably operating within the scheme. As I've said, we do have government guidance, we have the Treasury Directive, and we also have the Coronavirus Act 2020 that all underpin the scheme, have hundreds of articles and opinions. But what I wanted to say here is that the key point and takeaway for me is that a great deal of decisions around the scheme will vest with the Treasury. So they're unlikely to look favourably on creative solutions. We're getting a lot of clients coming to us with ideas and thoughts on how they can use furlough creatively. And all I will say is that don't go against the spirit of what the scheme is intended to achieve. You need to be really mindful that if you furlough staff without taking steps to protect yourselves, the business, you may be faced with a situation where you cannot recover those salaries under the scheme. The obvious example here is not having evidence that the employee agreed to be furloughed in the first instance. Now, As an employment lawyer, I don't normally recommend being unduly risk adverse. It's about managing risk and reward all the time. But here, because the power vests with the Treasury, I don't think it makes good business sense to bet against the person who's deciding whether your bet is valid. So don't be unduly risky, in my view. I just wanted also to mention here that it's noteworthy that the latest guidance on the 1st of May does place a greater emphasis on preventing fraud, and HMRC will be checking claims and potentially withholding payments or ordering repayment if they see dishonest or inaccurate information coming through. If that weren't enough, there's also now a portal for the public to report suspected fraud. And it's easy probably to assume from this that you'd only need to be conscious to avoid fraud, but in my opinion, we need to be alive to the prospect of the scheme being abused, and to the extent to which the Treasury are going to curtail these claims cannot be predicted at the moment. So again, I just urge you to sort of stick with the letter and the spirit of the guidance. Equally, don't be scared of furlough. If you've got a genuine need to do it, don't be shy. That is what it's there for. 4 million of us are already using it, and we can help you with this. There are a few, as always, there are a few areas that have not been covered in the latest guidance. Two of these, the first one probably being holiday pay. We're still really unclear as to if you take holiday during the furlough period, does that reduce the time you spend on furlough? So that minimum requirement of 3 weeks for furloughing an employee, if they take a week's holiday during that time, does that mean that they've only been furloughed for 2 weeks and therefore don't satisfy the minimum period? We don't know yet. We suspect not, but we will have to wait and see for the more guidance in respect of that. Also, another area still under scrutiny is whether you can furlough someone on statutory sick pay or whether you have to wait till the statutory sick pay comes to an end. Again, we need to just be mindful of the fact that the government is still finding their feet. Employment law is complex. You disturb it in one area, it stirs in another 10 metres down the road. So we just need to probably just wait and see what happens when the government gets to grips with these additional points. I say it's probably likely to be months before we get those clearer pictures. The last point I just want to make on this slide really quickly is that the scheme does not change employment law. You cannot therefore force an employee to go on furlough. You still have to stick with the parameters of your employment contract and agree any of those changes. It also means that the equality protection remains, so normal discrimination laws, and following from that stands to reason that you cannot furlough all the women and make all the men work, for example. We are already seeing a few claims emerging around selection for furlough, so we will have to watch this space, and I expect the tribunals might be busy in a year to 18 months' time. The best advice I can give you here is just follow the guidance, listen to your workforce, and just sense check your decisions. It's not there to trip you up, not on this occasion anyway. So just some healthy dose of common sense is probably what you need right now. So just moving on to the next slide, it's just the exit strategies there. What does life look like after furlough? So a lot of you will probably already be thinking about this, but I can't urge you enough to put plans in place now. These plans need to be agile as things are clearly shifting on the ground on a daily, weekly basis. So what are your options there? So first, can you just reopen your doors and return to normal? It's probably the most desirable but most expensive route for all of you. You'll need to give your employees notice that they're coming back to work. You'll need to consider any specific procedures for doing so. Just last night, for example, we're aware now that there are 7 government draft rules for UK workplaces to ease lockdown, and it's various guidance for factories, restaurants, office workers to set out exactly what parameters you should be putting in place. The crucial one for me that I've picked out is that if you employ more than 5 people, you will have to produce a written risk assessment of working conditions for your staff if you want to reopen. And you will need to think about key measures like staggering start and finish times, one-way systems, keeping personnel consistent on shifts, and those sort of things. That is where we're going to see a huge spike in COVID-related claims on health and safety and whistleblowing, we anticipate. So what that means to me is that you need a tailored policy that's going to address the government guidance, your own practice, your own working practices, the legislation, and I'm afraid that does mean a bespoke COVID policy. Yes, think about it. Secondly, are you going to have to consider cost reductions, but not headcount? Possibly, you would be considering pay freezes, pay cuts, reducing hours of work. But a couple of more novel ideas I've seen is extending the furlough period post the government scheme, even though you don't have the benefit of the scheme, but agreeing that anyway, and offering sabbaticals or unpaid leave. Lastly, I'll just touch on it. The R word is redundancies. We're going to have to think about it. The key for me here is just considering consultation and timings of this. There are minimum periods and heavy penalties if you get this wrong. And then just moving through the last slide there, just about creative thinking and challenges. Staff morale is going to be a big one. Have you thought about PPE? Have you thought about what policies and procedures you can put in place? Home working, flexible working, and new operating procedures. Social distance also being a big one. And my last slide there, I just clearly touch on how we can help you. The key thing for me is that I just want to give you some ideas today, but obviously there's a whole host of ideas we can share with you. We can help steer you through this, so feel free to pick up the phone. Thank you, and I'll hand you back to Robert.
Thank you, Rachel. Furloughing, the whole new world of COVID-19. So I can see lots of the questions that are coming in from you are related to furloughing. So I think the Q&A session will be particularly interesting for those of you that have raised got issues around furloughing. We'll move on now to a presentation of Dan DeSaules, who's a solicitor in the commercial team. And if us lawyers haven't had enough of furloughing, then we've certainly had enough of force majeure and COVID-19. So Dan will talk you through the latest issues that are coming out of commercial contracts. So Dan, over to you.
Brilliant, thank you, Robert. Good morning, everyone. So today I'll be speaking about your commercial contracts and specifically COVID-19 and obviously what effects that's had on the contracts. So I'll be kind of giving you tips as to what you probably should or shouldn't be doing. So I guess the first question, which I get asked quite a lot, and I think one that's really relevant, is will COVID-19 be classed as a force majeure event at all? And can I rely upon this in my contracts? Well, the short answer is it very much depends, and it would depend on to what extent COVID-19 has affected your contract. So has it delayed or prevented performance of the contract? And it'll also depend upon the actual wording of the contract as to whether force majeure type events are covered at all. So if the contract does provide force majeure events, does this specifically list or describe those specific type of events? For example, the common ones we see are acts of God, strikes, terrorist attacks, collapse of buildings, etc. So if the contract does not list any of those and it simply states or describes events as being beyond the party's reasonable control, the businesses will very much face an uphill battle to prove that COVID-19 does fall within that definition, and it's probably unlikely that you'll be able to rely on COVID-19 as a force majeure event to cancel your contract. Now, prior to February 2020, it's very unlikely that contracts will specifically reference COVID-19 as force majeure event. However, words such as epidemics or pandemics or government intervention or action may be referenced. Now, if those types of words are referenced, then the force majeure clause very much stands a better chance of being relied upon. However, there may still be further hoops for you to jump through as a party before you can be totally excused from your contractual obligations. For example, this could be if you're seeking to rely on that force majeure clause, then you may need to notify the other party. and you may have written obligations to also mitigate your losses. It's worth noting that if you are seeking to rely on a force majeure clause, then you as a party will bear the burden of proving that that clause applies. And if there's any ambiguity in the drafting, then the force majeure clause will very much be construed against you or the party that seek to rely on it. That leads me on to another point about mitigation. So as we know, the normal position in commercial contracts is that a party must always strive to mitigate its losses. And COVID-19 is no different. So if you are seeking to exercise your rights of force majeure, make sure that you do all you can to kind of start mitigating your losses arising from COVID-19 either now or in the future. Next slide, please. So aside from force majeure, then what kind of options do you have? Well, if your contract is silent on force majeure, then the doctrine of frustration may apply. Now, this is quite an archaic term and one which I've kind of heard many businesses use recently without perhaps kind of fully understanding the full effects or meaning of what this phrase actually means. And that's quite understandable, given that the sort of key legal cases in this area date back to the 1900s. So in a nutshell, if a contract is frustrated, then both parties' obligations under the contract will be deemed discharged. So this will happen where there's an event after the contract has been entered into, which makes it physically or commercially impossible to perform. So there are certain criteria to be met under the relevant act which governs frustration, and these are quite specific, so I won't go into those now. But what is important to note is that traditionally the courts have been very cautious in applying frustration to commercial contracts. One of the main reasons is because the courts traditionally do not like interfering with those contracts that have been sort of negotiated and concluded between two commercial parties. So the courts have very much taken a backseat approach and sort of very reluctant to get involved unless there is a fundamental point of law to address. That aside, proving frustration because of the inevitable court involvement will be very costly and time consuming, and the law does set a high bar to overcome, and that's evidenced by the very few unsuccessful cases on frustration. Furthermore, if you can prove frustration, or I think you have a very good case of doing so, then the party relying on that won't necessarily receive a great deal by way of compensation. For example, as I've mentioned, the party's obligations under the contract to discharge. In terms of financial remedy, the party alleging frustration may be able to recover any deposit amounts or other expenditure under the contract, but those remedies could actually be limited depending on to what extent the counterparty has actually performed the contract or taken steps to perform the contract. I think that's an important point that people kind of get mixed up with frustration and, you know, what exactly does it mean and what do businesses get from it? An important point to note is that if business does stop or delay in performing its contractual obligations because it thinks the contract is frustrated, it may in fact face a potential counterclaim for breach of contract and could be liable to pay damages to the other party if it was actually found that frustration did not actually apply, which, as I mentioned, is a very difficult concept to prove. So that's definitely something worth considering about before going down that route. Next slide, please. So all in all then, what practical tips can I be considering, or can you be considering apart from the law? Well, I think firstly, I'd probably advise avoid relying on COVID-19 as a force majeure event or actually claiming frustration unless it's crystal clear that you can do so in your contract. I think if it isn't, then you're going to face an uphill battle, and I think these concepts should only be used as a last resort. And one of the main reasons for this is inevitably any legal proceedings which are commenced on the basis of force majeure or frustration will obviously be lengthy, and given the expected economic downturn from COVID-19, there's no actual guarantee that the counterparty will be solvent by the time that proceedings are concluded. We're very much in desperate times, totally appreciate that, and sometimes that can force businesses into making decisions they probably wouldn't ordinarily make. For example, I've seen businesses out there who are actively and aggressively using COVID-19 to excuse themselves from contractual obligations without too much thought of the consequences. So I think these concepts should come with a health warning. Other points, if you are looking to terminate, then what other general termination or cancellation provisions are in the contract aside from COVID-19? You may be able to sort of terminate your contract on notice without further liability. However, if you are, then just be aware of the usual sort of notice for delivery, so serving it at the registered office, the counterparty, etc. I think a real practical point as well is can there be a new deal with the counterparty? You don't have to resort to COVID-19. Can you postpone or maybe reduce some of your obligations under contract? And that leads on into my next point. The focus, I think, should be very much on preserving your commercial relationships. So communication, negotiation, as ever, are very important, especially now. And I think the focus and efforts of businesses should actually be on maintaining those relationships rather than sort of destroying them with threat of litigation, etc. And I think above all, the main point from this, as you probably gather, is the very technical areas of law, both frustration and force majeure. And terminating contracts generally are as well. So always seek advice, because if these concepts aren't used correctly, then actually you could well open yourself up to potential damages claim for breach of contracts or otherwise. Thank you, Robert. Back to you.
Thank you, Dan, for that very comprehensive overview of COVID-19 and force majeure. As you say, a technical issue, but also a practical issue for lots of clients. And I can see a number of questions coming in from the attendees in and around force majeure clauses. I'm sure there'll be some questions for you, Dan, in the Q&A. So thank you, Dan. Passing over now to Richard. Richard, for those of you who don't know him, he leads our dispute resolution team and also our defence and security sector team. Richard is going to talk to you about business interruption insurance and issues arising from that as a result of the current situation. So, Richard, over to you.
Thank you, Robert. By way of introduction, as Robert has said, I'm head of HCR's Dispute Resolution Department, and I'm also a part-time civil court judge at the High Court and County Court in Birmingham. And I'm here to talk about insurance issues and in particular business interruption cover. Now, you'll be shocked to learn, because of my youthful looks, that I actually qualified in 1984, so I've been practicing for some 36 years. In the course of that period, I've seen a lot of changes in insured claims process, but there is a common thread, and that is that, and I should emphasize that this is not true of all, but true in a notable number of cases, that truth is the first casualty of a crisis. And whether by accident or design, there is misinformation from insurers about the extent of cover. And it is a fact that insurers frequently do tell claimants that they are not covered when in fact they are. So my first piece of advice is simply not to take the rejection of a claim at face value. Always investigate whether or not the cover actually exists. To illustrate this with an actual case, a notable case in my experience within the last 5 years, I was told firstly by the broker that this claim was not covered, to which I replied, well, I've read the policy and it is. Then I was told by the insurer the same thing, to which the same reply was given. Then by the insurer's panel solicitor, a top 10 UK law firm. Fortunately, I had a client with considerable fortitude, and the claim was settled before trial at £900,000 plus costs. So the bigger the claim, the more the insurer may wriggle, but the small print of the policy will tell you whether the rejection is valid or not. So check your insurance policy schedule. If you don't have a copy, you can get a copy from your broker or from your insurer. Is business interruption listed in the schedule of cover? It will often be linked to property damage or other factors such as storms, theft, vandalism, etc. It's often included as an add-on. You may not realize that that cover exists. So a careful check of the insurance schedule is important. If the schedule confirms cover, you then need to move on to the detailed policy terms to ensure that the particular instance that you are pursuing will be covered by the detailed terms of the policy. The words to look out for example, material damage proviso, which would link the cover to physical damage to premises or other tangible assets. Some policies will include special extensions and losses caused by notifiable human diseases. Some wording may be general enough for COVID-19 to be covered. Others will be restricted to specified other diseases. In many cases, the insurer will only cover a risk if the insurer can manage and value the risk. So they will deliberately restrict cover to specific known diseases where there is an existing vaccine. But the important thing to bear in mind is that policies are not all vanilla. Wording can vary a lot from one policy to another. And if wording is ambiguous, the ambiguity will work in your favor as a claimant. We lawyers love to quote Latin, and you may or may not heard of the contra proferentum rule, but the fact is that it's the insurer seeking to rely upon the clause in question, and any ambiguity will be construed in favor of the claimant. Next slide, please. So having established that the cover exists, obviously the next stage in the process is to make a claim and to test whether liability will be accepted. This may not be an easy process. History tells us that where there are multiple simultaneous claims, such as in the era of severe storms, drought, or floods, insurers tend to adopt a hard line and look to avoid claims. They may seek to rely upon limitation and exclusion clauses. The wording of those need to be carefully examined. Is the clause, for example, inconsistent with other parts of the policy? Is the insurer cherry picking in circumstances where there are other clauses which potentially would provide cover? Is the clause ambiguous? Again, the ambiguity will work in your favor. If the insurer accepts liability, the next step will be to carefully quantify your claim and collate evidence to support that claim as swiftly as possible. The indemnity period will dictate the extent of the recoverable loss. The maximum indemnity period as defined by the policy will usually be 12, 24, or 36 months from the relevant incident. It should include tangible and intangible losses, and ensure that your claim is quantified based on forecasts, not just on historical data, including seasonal variations, any planned expansion of the business that can be demonstrated. And it's always a good idea to consider using a professional loss adjuster with experience of quantifying and proving insured loss claims. As Dan has already mentioned in relation to contracts, the claimant will have an obligation to mitigate or minimize its loss, and therefore it will be necessary for you to consider ways in which you can prove that appropriate measures have been taken to restrict the loss to the minimum amount. If the insurer repudiates liability, sorry, next slide please, you need to consider what steps can be taken to challenge that repudiation if you consider that it's not based on valid grounds. You will need to follow any formal appeal or complaint process as a prerequisite. If that does not conclude in your favor, then you may consider the Financial Ombudsman Service, which now covers the Insurance Ombudsman. That will cover micro enterprises and small businesses, which includes sole traders, partnerships, and limited companies. That process can avoid the cost of the court process. By way of definition, micro enterprise is a business with a turnover or annual balance sheet that does not exceed 2 million or employs fewer than 10 employees. A small business is any other than a micro enterprise with an annual turnover of less than £6.5 million, or a balance sheet value of less than £5 million, or employs fewer than 50 people. The scheme also covers charities with an annual income of less than £6.5 million and trusts with a net asset value of less than £5 million. Individuals who are personal guarantors to loans to businesses they are involved in are also covered. The next issue will be to consider, in cases not covered by business interruption cover, are there other forms of cover that may assist to cover the claim? And one area to consider is firstly legal expenses insurance. Do you have cover for the cost of pursuing a claim with the assistance of a lawyer? That takes away cost as a reason not to pursue. The policy may require you to use the insurer's own panel lawyer, but you may be able to use your own lawyer, the lawyer of your choice, when court proceedings are necessary. Also consider directors and officers cover. Policies frequently cover both the company and its employees. The definition of the insured parties will be important. Does this cover all employees or only those who are registered directors or those performing a management function? Is there an insured on insured claims prohibition? If there is not, then a company can recover losses caused by its own employee, even though the employee is an insured party under the same policy. The allegation will be that the responsible person should have assessed the risks, the events which pose a significant threat to the business, and for example, have they adequately discharged that function? Is the indemnity period sufficient? Did he consider the period necessary for the business to be able to trade effectively again? One notable recent example has been the All England Club, who are paying an additional £1.5 million per year for unrestricted pandemic cover. This can be friendly litigation. There's no acrimony involved. It is simply a means to engage insurance cover, and with senior employees frequently there is a conversation between the business and that employee for them to understand that this is simply a means to an end. We have condensed the step-by-step process of pursuing a business interruption claim into a flowchart, which can be supplied to all delegates to this webinar after this call. Thank you very much.
Thank you, Richard. A really interesting area at the moment for anybody facing interruptions in their business. I know, Richard, your team's been inundated with lots of queries from clients about business interruption insurance, so there's sure to be some questions from the attendees for this morning's Q&A. So you've now heard from all of the speakers. Thank you to Harry, Rachel, Dan and Richard. We'll now pass over to the Q&A session, and we've got plenty of time for that this morning. I thought it would make sense to actually, rather than sort of mix all the questions up, to do them in the order in which the speakers presented this morning. So starting with Harry. Harry, one of our attendees wants to know what's their recourse if their bank turns down their CBILS application without good reason, and is there a process, is there a mechanism, what are the rules, what are your practical tips for dealing with that situation?
Thanks, Robert. Yeah, there's no prescribed recourse for a bank turning you down in relation to a CBILS loan, but I'd probably question at this stage whether you want to go through the whole process of appealing and taking it to that level when perhaps businesses need the cash in more immediate terms. So the way I would probably approach this is get as much feedback from the bank as you can as to why they've turned down your application. Perhaps that can lead to you adjusting your modelling or forecasting and the application itself. And of course, there are a number of other lenders that you could approach under the scheme. So it might be better to look at going through another provider rather than your existing one that might have the different have wrong sort of credit parameters for what you're after.
Okay, so there's no formal process, but it's worthwhile looking at feedback and potentially looking at alternative banks and lenders. Thank you for that, Harry. A related question, of a similar fashion, concern that a client's bank is forcing them to use an overdraft rather than taking a seal bill. Alternatively, will make them take a lower level of loan rather than the level that they requested. What are your thoughts around that, Harry?
Again, this all comes down to your application, I'd suggest. So if your assumptions and your forecasts are reasonable and show where the business is actually going to be short of cash and by how much, that's the best evidence to put forward to banks to how much you need to be borrowing. In terms of them forcing you to use your overdraft, they can't, of course, force you to draw on the overdraft, but they will be fairly reasonable argument from their side to say, well, you have the facility here, why not use it? And you have to give a pretty good reason not to. So again, I'd look back at your application itself, the forecasts, the assumptions, and use those arguments.
Okay. And presumably, Harry, that's something that you and the banking team are able to support clients on in terms of preparing their initial application and then reviewing any response to those applications.
Yeah, absolutely. We've got experience of doing that, and we've made a number of successful applications for CBILS processing and working with a number of clients on doing that. So yes, please do reach out.
Okay, great. Thank you, Harry. Well, Harry, you'll be pleased to know that's all the questions for the attendees so far on banking related issues. Thank you for that, Harry. Rachel, as you can imagine, we've been inundated with questions on furloughing, and I'll pick just a few, conscious of time this morning. Concern around criteria for furloughing and then subsequent ability then for them to justify who they've furloughed and not furloughed, and potential auditing from HMRC at a later date. What are your thoughts about selecting people for furlough and having the justification and then defending that justification, if you like, at a later date, which could, I think, be as long as 5 years' time, couldn't it?
Absolutely, yeah, could be up to 5 years' time. So I think my main message here is to really do think about your selection. You can't force people to accept furlough, and you also equally can't be forced to put people on furlough. So think about areas of the business where there is a downturn, where there is exposure or closure, and think about those, and potentially, as I said in my talk, just really be mindful of the Equality Act provisions and make sure you're not being discriminatory in any of your selection processes. And keep a record of who you're selecting and why. I have some employers who are actually recording their board meetings or their senior management meetings where they discuss this. So they've got a live a Zoom record of that is one option, or take a note, just so that in, like you say, Robert, 5 years' time, you can look back and go, I did this for that reason, and give you that sort of protection there.
So record it, and if in doubt, record it again, I guess would be your summary advice there in terms of making furloughing decisions. Thank you, Rachel. A practical question now from one of the attendees who's given us this question during the session this morning. They're a freelancer, Rachel, working through a limited company, and they furloughed themselves if they can do it. But what's their ability to actually generate new contracts while they're on furlough?
Yeah, I saw this one, Robert. Now, the question I have is a freelancer. So are you self-employed or are you an employee? So you can only furlough yourself if you're an employee working through your limited company. I use the word freelancer meaning self-employed scheme. There's the self-employed, it's called the self-employed income support scheme, that you might need to look at as well as furlough. certainly under the first of those, the self-employed scheme, you can look to generate other revenue. Under the furlough scheme, you need to be careful that you're not providing work and services. So I think that it's a bigger grey area, and I would just sense check exactly what you're doing with one of us, because it could be considered generating income that would fall foul of the guidance.
Yeah, I think that point about if in doubt, take advice is probably very true to lots of these issues that clients are facing at the moment. And I know across the whole firm, we're receiving lots of phone calls and emails from clients wanting to quickly drop in and sense check what they're doing at the moment. And that's really very true about furloughing and what activity you may or may not be doing whilst off on furlough. So thank you for that, Rachel. Another question around furlough, about the fact that it relies upon agreement with employees, and the question about, how do you go about reaching that agreement, and how much can you rely upon that agreement, bearing in mind the potential imbalance of power that the questioner poses in terms of the employer and employee relationship. What thoughts do you have on that process, Rachel?
Yeah, it's a really good point, and an absolute key point from the guidance is this agreement. So does the agreement simply be you writing to the employee and them accepting it, or does there need to be a written agreement back from the employee? Because I'm erring on the side of caution and a bit more risk adverse than I usually am because of the wishy-washiness of the guidance, I would say I would like to see written confirmation back from the employee that furlough has been accepted. That's fine in an email or a written note of a conversation, but there needs to be an agreement both ways. As for the imbalance of power, I think there's a lot of information out there. As long as you are giving your employee all of the facts, stating exactly what furlough is, what it means, and being very clear, communicating well, I think that one is covered with that, as long as you are, supporting your employees and being there and answering any questions they have. Certainly you cannot force furlough through. So if an employee doesn't want to accept it, the way we're dealing with that is obviously talking them through the options. Quite often they'll find that the alternative options are much less attractive. Okay,
thank you for that, Rachel. Another furlough question, I'm afraid. We've got lots of them this morning. I think this one is a question that lots of clients are asking us at the moment. Lots of concern that when staff return from furlough, that they'll very quickly start submitting holiday application forms and then wanting to go off on holiday just at a time when businesses are trying to get back on their feet and rebuild. What's your advice to employees on what to do with staff and holidays while they're on furlough, and then how to manage that inevitable holiday request that's going to come in once they're off furlough, or indeed the business is back and staff are back in the offices?
So again, that's a tricky one. So the first thing is you can take holiday whilst you're on furlough. The issue that is still outstanding is whether that reduces the amount of time you spend on furlough. So my advice here is that you could seek to urge employees to take holiday whilst on furlough and then extend the furlough period, if it's only a minimum of 3 weeks, by any period of holiday, so that you get holiday that's been accrued or has accrued to date taken during the furlough period. You can, under the working time regulations, request that your employees take holiday as long as you give them the same amount of notice as the length of the holiday. So you can do that. The alternative is that the working time regulation has been extended, so you can now carry over holiday for 2 years. So you can reassure staff that if they are prevented from taking holiday during furlough or after that, because business is manic when we come out of lockdown, which hopefully might be the case for some of us, then you can say you can't take your this week, this year, but we'll let you carry it over to preceding years.
Okay, thank you, Rachel. I think, again, the advice would be, if in doubt, quick phone call or email to check the point and then take it from there, isn't it? It's bound to be an issue. When businesses get back up to full strength. Okay, one last question for you, Rachel, which is kind of furlough related. Can employers force staff to take a pay cut to reduce their costs? Obviously not a furlough question itself directly, but I know lots of clients are looking at this currently at the moment.
Okay, well, you say force, really depends what your contracts of employment say. So do you have the right to do that? It's short-term working, layoff or otherwise. So that could help, but certainly you can't force it. It's an agreement that needs to be had with consultation with those members of staff. Quite often, again, when you look at the alternatives, some people may be more happy to agree than others. And also just be careful there about what parts of the business you're applying it to and to who, just to make sure there's no discriminatory elements. So is it a blanket pay cut for everybody, or are you picking pockets of the business to apply it to? But again, no, don't force it through. Could be considered a breach of contract to do so, and you could be faced with unfair dismissal claims.
Okay, thank you, Rachel. Lots of questions there on furloughing. For those of you where we haven't answered your questions just now, don't worry, there will be answers following up in the email that comes after this webinar this morning. So Dan, turning to you on commercial contracts and COVID-19 and force majeure, a question here around the latest Cabinet Office guidance to the public sector, telling them to reject force majeure claims and to look to work proactively with suppliers when negotiating their terms. And perhaps a more general question than the one posed by the attendee, which is, what evidence do we see about pragmatism across commercial contracts in the public sector as a result of force majeure? But perhaps a wider question about what evidence of pragmatism are we seeing generally across commercial contracts, both public sector and private sector, as a result of COVID-19 and force majeure. Do you want to comment on what we're seeing across the whole team?
Yeah, definitely. There's a real mix, if I'm honest. So, you get everything from actually the parties being really proactive, and they've kind of, ever since sort of February, March time, they've actually putting plans in place, or they've got, current exit strategy in the contracts, or they've got something already in place. So a lot of the clients that we're seeing are kind of ahead of the curve. For those that aren't, I think it depends on from what bargaining position you start at, because a lot of clients that I've seen at the moment are sort of using, like I say, force majeure as kind of as a sword, not a shield, so to speak, and they're being aggressive, or they're kind of trying to take the bull by the horns to, cut costs to get out of the contract, which actually the business relationship just isn't working currently, and they see this as an opportunity to get out. Right across the other spectrum, like I say, where people are actually proactively working together. So I think because, the concept of force majeure and frustration are so, technical terms, and they're so based on interpretation and subjective, sort of outlooks. I think it's very difficult to have a consistent approach across the board. So I haven't really seen that consistent approach from my clients as yet. And like I say, I've had a lot of sort of differing views as to whether they can get out of the contracts, whether they can't, or whether the parties just postpone the actual supply of goods or services, etc., until this kind of blows over. Now, of course, we don't know when that's likely to be, and obviously there's cash flow issues involved in that. But I'd probably say, as a percentage-wise, probably 50-60% are looking to proactively work with the other counterparty, whereas the other 30-40, particularly those in the events industry, for example, are very much acting out of last resort desperation, and that's where you get the feud between the parties.
Okay, thanks, Dan. I think it's true to say that we've definitely seen a mixed approach from clients across the commercial team, but I think it's still very much early days, is the other sentiment that I would add, and I'm sure in due course matters will end up moving from the commercial team to the dispute resolution team as issues become more serious and more pressing on those related issues. Dan, one further question for you, if I may. It's of a similar nature, really. Are we seeing clients taking the opportunity to more generally look at renegotiating contracts to reduce costs? Those of us that were around 2008, 2013 will of course be familiar with what went on then. There was lots of contract renegotiation to cut costs. Are you seeing any of that going on at the moment, Dan, outside of force majeure and COVID-19?
Yeah, definitely. And I think, COVID-19 is probably just the catalyst at the moment to kind of bump that along. But I've done a few sort of addendum to contracts this week, actually, in that very same nature. So obviously most contracts will have variation clause within that, providing the parties both agree to variation, whether that's on cost or, minimum obligation changes if you're talking supply of goods, for example, or, postponing for a length of time. I've definitely seen, negotiations of a good nature in terms of, getting both parties through this tough period. And there is no point in making enemies at this point in time. It affects everyone. It affects all industries, and and of course there are some industries, PP, the healthcare sector, for example, which are thriving. So actually, there's new contracts coming out the woodwork in terms of those, and some software companies as well behind the scenes helping those type of companies. So you've got the positives as well as the negatives, and it's similar to. I know we haven't really heard this word for a while, Brexit. It's similar to that. There's always going to be negatives, but there's always positives as well. And I think that if you can focus on the positives, from a business perspective, and work collaboratively with the other party, then that's what it's all about in terms of, you need benefits for both parties. One of them needs to give and one of them needs to take. So why not work on a collaborative approach now? I think it's the crucial time more than any to start those negotiations.
Yeah, I think that's right, Dan. I think it's still early days, though, isn't it? And I think almost inevitably some of those negotiations will become disputes in due course. But we'll see what happens there, and whether it's a rerun of 2008 to 2013. Thank you, Dan. That's all the questions for you this morning. Richard, just a couple of questions to you before we close off. The first one, a technical question, if I may. What's the true meaning of business interruption? And how is that interpreted in terms of business interruption insurance?
Yep. So the first place to go will be the definitions clause in the policy. So we're looking for how the policy defines business interruption, which will usually be something akin to an inability for the business to operate at all, or unable to operate in the way in which it usually operates. And that will be inability or reduction of business due to uninsured risk. I mentioned earlier material damage proviso, and without being unduly pessimistic, I do have to say, having looked at a lot of these policies over the course of the last few weeks, there are very few which can be said to cover COVID-19 as an insured risk, but they do exist. With a material damage proviso, for example, the inability to operate the business is going to have to be linked to some physical damage to premises. So it's a policy by policy question that needs to be addressed by reference to the detailed and exact definitions given in each policy as it arises.
Okay, thank you for that, Richard. And then one final question then, Richard, for you, and then before we wrap up this morning. Quite an interesting question, actually. Would public or employee liability insurance protect a business if a contractor on the business premises falls ill and dies with coronavirus, or passes on the disease to somebody else in the premises?
What a good question.
A good question for the last one, Richard.
A very good question. So potentially yes. Again, it's all going to fall down to the detailed terms of an individual policy. But an employer will be liable for the health and safety of his employee wherever he works. There's a whole history of cases around shipyards and some fascinating legal arguments about whether welders could be said to still be the responsibility of their employers when they're working on other people's premises or within ships. But yeah, public liability and employers' liability insurance are likely to play a role in that scenario. And in every case, anyone seeking to rely on that type of cover will need to consider the detailed terms and conditions of the policy. But my general answer is yes, potentially, but it will all come down to the wording of individual policies. And
back to the ever old, if in doubt, take advice and get the policy checked. So,
sorry, I should say, just as a rider to that, Many insurance companies will be issuing guidance to their policyholders. And one thing that is important is that everyone is aware of whatever guidance is being issued so that they can follow it as closely as possible to avoid an insurer being able to disclaim liability later simply on the basis that the guidance wasn't adequately followed by their own policyholder.
Right, okay. Thank you for that, Richard. That concludes your question and indeed all of the questions this morning. I know we've had a question from one of the attendees asking how we'll respond to the questions we haven't dealt with. So for those of you that haven't had your questions replied to, either the ones that you submitted in advance or the ones that you've posted this morning on the chat, don't worry, we will be replying to those. There'll be an email going around later in the next few days with both a copy of the webinar, so you can watch it again if you want to, and also replies to the questions. But as always, with any event that we run, if you have got questions afterwards that we haven't answered or you want to pick up in more detail, please contact me or any of the speakers, and you'll find their details on our website, www.hcrlaw.com. And by all means contact them and pick up by email or phone any further questions or further issues you want to pick up. So first of all, thank you to our speakers this morning, Harry, Rachel, Dan and Richard, very informative as always. Thank you though to all of you who've attended. Very much appreciate you joining us for our first Harris & Clark Rickaby's webinar. We had over 50 attendees throughout, so thank you for joining us. Our next webinar is on personal wealth and planning arising out of COVID-19, and that is on Wednesday the 11th, so next Wednesday, Wednesday the 11th at 11 a.m. And as part of the email that you receive after this webinar, you'll be able to link through into that event and book a place. That concludes the proceedings this morning. So thank you again to our speakers and thank you again to you for attending. I hope you all keep safe and keep well. Thank you very much, ladies and gentlemen.